Okay, we are about to start panel 3, so help yourself to that extra coffee and we'll get started. For those of you who are online, just a note that Laura will be monitoring chat, so if you have questions that you wish to pose to any members of our panel after their presentations, we'd really love to hear from you. So this next panel, panel 3, is giving us a chance to explore not only the process behind old age policy, but key choices that are being made. And I think you'll see a theme emerge around tensions between protection and paternalism and what each mean. We're going to go in the order on your program, except that unfortunately Professor Arias can't be here today. But if you have feedback on her paper, as Susanna mentioned at the beginning, we invite you to share it with her. So without further ado, it's my great pleasure to recognize Alison Barkoff, who is the Harold and Jane Hirsh Health Law and Policy Associate Professor and Program Director at the George Washington University Milken Institute School of Public Health. That must be fun to put on a business card. Prior to that role, she led the administration of community living in the U.S. Department of Health and Human Services. Alison?
Thanks, Nina, and it's a real privilege to be here today. Thank you for this convening. And I'm excited to talk a little bit about the paper that I put together, which was really looking at aging through an intersection with disability and both the opportunities and challenges of coordination across aging and disability around federal policy, advocacy, and service delivery. And just to give a little framing of the impetus for this, as might be obvious, I was privileged to lead the administration for community living from 2021 to 2024 and was involved in its creation as an agency in 2012. And for people who aren't familiar with ACL, it was an agency that was created during the Obama administration, bringing together aging and disability programs from across HHS and eventually other departments to really focus on the common goal around an interest in community living and supports and services that help both older adults and disabled people be able to do that. The Administration for Community Living funds a network of about 2,500 community-based organizations that provide direct services like in-home supports and senior centers and legal advocacy. It plays a really important role relevant to some of the other papers here around protecting older adults and people with disabilities through programs like Adult Protective Services. And really importantly, the head of ACL and ACL as an agency serves as the advisor to the Secretary on Aging and Disability Policy. We are in a moment in time where a lot is changing in the federal government. And so my reflections on kind of 4 years and really 13 years of working with ACL in some ways became an homage to ACL when a few weeks ago the administration announced the dismantling of the agency, and I think it puts a little bit of a different frame on the paper. I want to start by really talking about both the commonalities and the differences between the communities, and I actually think many of the topics I talked about spread across literally every one of the papers here today. As we heard a little bit, they are hugely overlapping populations. Many older adults have functional limitations that under disability rights laws would make them people with disabilities, even if they don't have that identity. And actually, older adults are the largest subpopulation of people with disabilities. So a real commonality, and many disabled people aging with and into disability. In terms of the shared priorities, which I think really has been the centerpiece of ACL and advocacy, we heard a lot about the interest in people aging in place and living and being part of their communities, and really the shared goal around increasing access to home and community-based services. The second piece of that is really a shared interest in making sure that the people who provide community services, the direct care workforce, is strengthened. And that's been really another area where we've seen a huge growing demand, yet a very unstable workforce, and an area where the two communities have worked together. In part because of the lack of formal supports, we have 53 million family caregivers in this country who are helping people age in place, helping disabled people be part of their communities, and a real common interest around supporting those family caregivers that, in essence, are the backbone of our long-term care, quote-unquote, system that we really don't have. Another area has been around affordable, accessible housing, both for people with disabilities and older adults. That's been an area where we do a lot around thinking about access to services, but if you don't have a home that is affordable and that is accessible, then that is another reason why people end up in institutional settings. And then finally, and I think we'll hear more about it here, but this intersection of discrimination, both ableism and ageism, and for many people, sometimes those intersecting types of discrimination and the commonalities about the bias that both disabled people and older adults face really in many aspects of life, access to health care and employment settings, et cetera. So lots of commonalities, yet one thing that I certainly have learned both inside government leading ACL as well as really being part of the advocacy community is there are many differences that really have to be respected when you're bringing these communities together. Just to give a couple examples, and we actually are talking about several of them today. One is around physician-assisted suicide. I think I would describe it as maybe the third rail in ACL, despite any attempts at bridging. There really is this view around kind of dignity in dying that's really driven out of the aging community, and from the disability community, a view of many of these types of physician-assisted suicide as a deadly form of ableism, and really a place where the communities have very, very differing views in entering into that conversation. Another is a real difference around the approach to nursing homes, and as we heard a little bit about in the last panel, the fact that we have a healthcare system that in our only funder of long-term services and supports has what many people call an institutional bias with an entitlement to nursing homes and community-based services that are optional. I think there's been a lot of differences across the community about the value of kind of investing in nursing home improvement and whether from the aging perspective, people are there. It's really critical that we keep people safe. And sometimes from the disability perspective, seeing more investments in nursing homes as kind of antithetical to some of the rebalancing efforts. And then finally, one place where I think I've seen really bridging over the last decade or two is around approaches to guardianship, which historically, from the aging perspective, if you look back quite a ways, really focused on kind of improving guardianships, addressing abuse and neglect, and the disability rights really came from kind of eliminating guardianship to, I think, what we heard on our first panel, some real kind of places where the communities are coming together. Want to touch on how bringing together aging and disability has had a real impact on federal policy, and I think there are a few examples. In the last administration, there was a lot of efforts around new regulations, and I just want to give an example or two where something that could have been just aging or just disability really focused on the intersection. The Older Americans Act regulations were updated for the first time in over 30 years, and included in the regulations is real focus on the coordination across the aging and disability networks, particularly for entities that have some overlapping jurisdiction, like the Long-Term Care Ombudsman Program and the Protection and Advocacy Networks, both that are rights-focused, both that go into institutional settings. Some real bridging perspectives around guardianship and really bringing in a little more of that rights-based focus that is the place where the two communities have come together. And then also recognizing that older adults with disabilities are one of the populations of greatest social need. And the Adult Protective Services regulations, I think people think of that as just an aging framework, but actually it covers adults with disabilities. And similarly, some of the rights framework that we'll hear about from MT and David and others was really brought in concepts of self-determination, and the disability concept of dignity of risk was brought in, and again, some coordination across networks. And then on the aging side, talking about the 504 regulations and really recognizing that so many older adults are also people with disabilities. We've also seen a number of initiatives funded across commonalities, and I think really importantly, we have seen the spread and the real community engagement on the advocacy side, and I would say particularly around issues of fighting to protect Medicaid in this current moment in time, legal advocacy where kind of Olmstead and disability rights has been brought into aging, and actually at the state and local levels, partnerships. I'll just end by saying that I think there has been great value both in federal policy, in advocacy, and in state partnerships, and ACL has been an impetus. And the real question for us now is how to keep that moving forward with a potentially very different ACL. Thank you.
Thank you, Alison. Our
Nina,
next
can
speaker...
I just interrupt for 1 second? I apologize. I wanted to let folks on the live stream know that if you do have questions that you'd like to send our way for the rest of the afternoon, send them to our email address. That's the best way. It's Petrie-Flom, so Petrie-Flom @law.harvard.edu. Thanks.
Thank you so much, Susanna. Our next speaker will be Joan Braun. Joan is an assistant professor at Bora Laskin Faculty of Law in Thunder Bay, Canada, and her research lies at the intersection of age and disability with a special focus on elder abuse. Joan?
Perfect, thank you very much. So I'm going to just give a little bit of background to my paper. Much of what my remarks are covered in the paper, but I wanted to give a broader context and provide some of my observations. I'll just start by mentioning in the paper itself, I reference the study that most of my findings and arguments are based on, but I'm also involved in a subsequent study which is looking at the same statute but from a different perspective. But by way of context, since we come from different jurisdictions, I thought it would be worthwhile by mentioning what I'm using the term adult protection for and Canadian approach to adult protection. It's worth noting that not all provinces have adult protection legislation, which I'm defining as legislation that provides protection to adults living in the community, so not just targeting, say, a long-term care home. Where those statutes do exist, there's very limited mandatory reporting, and what's probably most important to my paper is that they're rarely in a standalone APS agency. The statute that I talk about in British Columbia actually is run by the health authorities, and many of the designated responders actually are social workers who also have healthcare tasks. And agencies can only intervene with the consent of the adult. So interventions contrary to the adult's wishes, such as substitute decision-making, can only occur if the adult is incapable. But there's kind of, I should say, there's a formal incapability assessment if it's more longer term, but in emergencies, it's really left to the health authorities to determine if someone is incapable or not. So the BC legislation, it's also worth noting that although I use the term adult protection, that's not actually the history of it. That term was added to it along the way, and if any of you are curious, ask me at the break and I'll explain how that happened. The original intention of the purpose was to provide support to adults unable to access it on their own, and the focus was really on support, minimally intrusive responses, and in fact was actually influenced by some of the disability rights legislation going on at the time. It came in the same package of legislation as BC's Representation Agreement Act. So it has kind of an interesting study. But what's always interesting about studies is, even though some have said that some scholars have said that this legislation is modern, it's supportive, the question is what happens in practice. So that was the purpose of the study. And what I found, as far as the findings were concerned, was that individual responders, mostly social workers, were very committed actually to doing a supportive approach to minimizing intrusion. In fact, they talked about how they could mitigate the risk of abuse through support and avoid substitute decision-making, which they worked very hard to do. They also provided interesting illustrations of times that they almost took on an ad hoc supportive decision-making role, like a supporter would in that kind of arrangement, where they actually one-to-one offered support that helped the adult make decisions. And I should note that even though the statute isn't directed at older adults per se, statistics show that most cases involve older adults with dementia. So findings continued. What I did find also, though, is there was this real dichotomy because of systemic issues and resource shortages. The study's participants said they couldn't always use a supportive approach, and what was really kind of devastating was that they actually provided examples of times that they believed a support was provided earlier, it would have mitigated the risk of abuse, but the situation was allowed to escalate so that really intrusive interventions were used later. And also that confusion exists about the concept of incapacity. This statute is run by the health authorities, so capacity assessment's done for other purposes, so they were leaving great confusion about what a determination meant, and examples were given of, say, doctors saying, I don't believe that person's capable, and then the person being treated as if they were legally incapable, those mostly being adults with dementia. So my implication really is that I believe that there's a gap between the statute as written and the statute as implemented, and also because of the confusion about the meaning of incapacity, and due to these other systemic issues, substitute decision-making ends up being used more extensively than merited or intended by those that drafted the statute. And this contrast between intentions and what's now occurring actually can be seen in, for example, a case where the health authorities used Section 59, which is an emergency provision, to actually detain a woman for 9 months without court authority, which the court said was a charter breach, and with a recent study that shows that these types of detentions are occurring way outside the scope of the legislation. So what we have in a nutshell then is an intention that the primary component of the response be supportive, that the statute align with human rights, disability rights, and that substitute decision-making interventions be rare. But the reality is that the scope of substitute decision-making mechanisms has grown, particularly in emergency situations, which results in gray areas and rights intrusions. And so this was very interesting in talking to the study's participants, because they actually used the term gray. They said there was a lot of gray, particularly when it comes to capacity assessment. And I ended up coming up with 2 illustrations which are attached to my paper, one kind of showing how the statute should work, with most of the focus being on support, and then substitute decision-making with a clear line of a capacity assessment in between. But this reality where really substitute decision-making has kind of grown in a kind of a de facto basis, and where there's this gray area where sometimes adults, particularly those with dementia, are treated as if they are legally incapable and don't have the right to decide, when there's actually been no determination at that particular point. And so I came up with some recommendations. One of the things that I find astounding about this statute is even though if you look at the documents of discussion in the legislature when this bill was coming in, there was so much discussion about support and how this would offer support to those who can't otherwise get it. But nowhere in the statute does it say that the health authorities, who are also called designated agencies, that they actually have to provide support. It's left to their discretion. So you can imagine what a problem that creates when there's resource shortages, rationing of resources will go on and support isn't provided. So I think that one important change would be to add a provision that clearly states that in certain circumstances where certain criteria are met, that they need to provide support, and obviously an increase in funding to make support available. And I think that really the goal that I would be hoping for would be to use support and supportive decision-making and other types of support to the largest degree possible, and to only use substitute decision-making interventions or interventions against the wishes of the adult where support has been tried and is not successful and it's not adequate. So some changes need to happen to do that. I also pondered a little bit about whether a new adult protection model is needed. I mean, one of the things that really struck me in looking at this dichotomy is if it was just the work of the designated responders, they really told some gripping stories about times that they were able to, by providing support or even taking on this role, much like a supporter in a supported decision-making relationship, how they managed to prevent further abuse and preserve the person's right to decide or help the person's wishes being fulfilled. But that support wasn't always offered because of shortages. So it made me thinking about whether a new model is needed and about the viability of this type of hybrid model. And so first of all, there's a lot of existing arguments. I won't say a lot, but some compelling existing arguments in the literature talking about maybe developing a new adult protection model using the concept of vulnerability. I think we should look at that more thoroughly. And also in light of the fact that this is an adult protection statute, where most of the people being responded to are persons with cognitive disabilities, it brings into some interesting questions having to do with the Convention on the Rights of Persons with Disabilities. I mean, what's happening on the ground sort of really showed that providing support can mitigate abuse and retain the person's right to make decisions while also letting their wishes being fulfilled and not stripping away their rights. So why not create an adult protection model that builds in some kind of requirement that support and supported decision-making needs to be the first step in cases where someone has a cognitive disability. I don't know what that would look like. This is just a preliminary idea, but I just put it out there. I think that would help to bring it in line with Article 12 of the Convention on the Rights of Persons with Disabilities, which is particularly important in those countries such as Canada, where the convention has been ratified. And that brings me to the end of my comments with 9 seconds to spare. So I look forward to the discussion, and thank you all very much.
Thank you, Joan. We're going to move next to a dynamic duo. We have Marie-Therese Connolly, who's the founder of the DOJ Elder Justice Initiative, formerly known as the Nursing Home Initiative, the lead architect of the Elder Justice Act, enacted with the ACA, a co-founder of the RISE model, and president of the RISE Collaborative, and a MacArthur Foundation Fellow, so the one person in the room who gets to claim to be genius, I suppose. And with her, we have David Burns, who's a professor at the University of Toronto. This is our Great Canadian Minds panel, where he holds the Canada Research Chair on Older Adult Mistreatment Prevention. He not only pursues research on elder mistreatment, but is actively engaged with a range of NGOs in this space. And most relevantly for today's talk, he's played a leadership role in RISE and its founding. So I'll turn things over to MT.
Thank you. We're so thrilled to be part of this amazing group. To get approval for a new drug like a statin, you have to show extensive evidence. But if you want to implement a public program that costs billions of dollars a year to protect vulnerable people, sometimes over their objection, no evidence of efficacy is required. In the mid-1900s, policymakers were hearing more and more concerns about older people who couldn't manage or who were being abused, neglected, and exploited. So they formed adult protective services programs modeled loosely on child protective services. And Congress funded 7 demonstration projects to study them. In 1974, the most rigorous of those studies, a randomized controlled trial in Cleveland, found that clients who received gold standard protective services died sooner and were institutionalized more often than those who did not. The other studies had similar findings. Despite this, all states created adult protective services programs, and their efficacy has not been studied since. Every APS program is different, but the core duties include, first, taking reports about vulnerable adults who are either at risk or being harmed, second, investigating those claims, and third, responding to crises. Some also handle forensic accounting, cognitive assessment, guardianship, and much, much more than anyone can do. All states but one also have enacted mandatory reporting laws requiring various professionals to report suspected elder abuse to APS. There's no evidence, as Nina has written, that those laws help either. Today, research shows that 1 in 10 older Americans is victimized by elder abuse, leading to massive harm, suffering, and cost. Only 15% of cases come to light. APS involvement also may lead to guardianship or criminal prosecution, even blunter instruments that raise even more concerns and are equally lacking in evidence of efficacy. The complexities are revealed by the cases. One mother's adult son with mental illness lived with her. He helped her get groceries and get to the doctor. He also took her money and sometimes threatened her. She wanted him out, but she didn't want to get him in trouble. Neighbors called APS after hearing loud yelling, but she just wanted to get help for her son, which APS couldn't provide, so she refused their help. It's cases like this that led us to want to design a new kind of program, and we called it RISE. We were solving for several issues. Whoops, there we go, okay. I asked David to remind me to do my slides, so I'm going to blame it on him. In any event, that's how the RISE Collaborative works. So, what are the problems we were solving for? They're listed there. Stated positively, we wanted to have a program that was holistic. Most systems are binary. There's one set for victims, like APS or guardianship, and another for perpetrators, like prosecution, but no help for other people in those older person's lives, like that mother's son, or for the relationships among them, even though elder abuse is defined as arising in relationships with an expectation of trust. Second, we wanted clients to be at the wheel, to start by asking, what matters most to you? The hypothesis about why those early studies had bad outcomes is probably because they overrode people's wishes, which often doesn't end well. And we wanted them to be explicitly grounded in theories of change, put them inside of a research project, and to fill huge gaps that David will now tell you about.
Thanks, MD. My apologies for not reminding you about the slides. Okay, so what we were trying to do with RISE and what we're trying to do in this paper is to try to sort of rethink and almost reorganize the way that we approach the response system around the issue of elder mistreatment and self-neglect. And so the current system is primarily centered around adult protective services. And so Adult Protective Services does a really good job of going out and doing investigations, making some kind of substantiation decision, but then the two pieces that have been really missing historically is sort of on both ends. On the sort of the right-hand end is like, so what happens if you find a problem, right? If you imagine yourself, you're doing therapy, and you're working with your therapist, and you kind of discover that you've gone through some kind of trauma, but then the next session, the therapist says, we're done, right? We need something that kind of goes further, some kind of intervention that works through the case towards some kind of resolution. And that's sort of what we're trying to do with RISE. On the other end is prevention, primary prevention, trying to prevent these things from happening in the first place. And again, that's what we've been trying to do. And so we work with older adults who are age 60 years and above, who are either at risk of or experiencing mistreatments. We try to, do that prevention and response, those response pieces. RISE stands for Repairing Harm, Inspiring Change, Supporting Connection, and Empowering Choice. These are the core modalities that we use. So this is sort of theoretically informed and designed using sort of evidence-based modalities. We used motivational interviewing with the older adults and their, when appropriate, the alleged harmers. It's something that's used with like reluctant client populations. When we are working with them at the level of their relationship, we're using restorative justice approaches. Building on evidence from our colleagues in the field, social support is arguably the most sort of strongest protective factor. So we really try to build social supports around them, and then empowering choice through supported decision making. This is an open access article that you're welcome to check out, but you can see that it also stands for relational, individual, social, environmental. We try to hit those different kind of levels of ecological influence in the cases. And so we have a couple of different sites that we've collected data through our, in our research. So in Maine, to date, we've worked with about 1,500 cases. We started in 2 randomly selected counties. Advocates, we call our caseworkers RISE advocates. They on average take on about 20 cases at a time, lasts about 5 months open case load. Our big finding was that compared to clients who received kind of standard APS, usual services, those that were exposed to the RISE APS partnership had significantly lower likelihood of coming back into the system. Okay, so that recidivism or recurrence outcome. And that finding was sort of found across each different mistreatment type. And then in Ontario, we don't have adult protective services, so we've set up a different response framework in which we have a centralized telephone line that anyone in the province can call into, older adults, service providers, concerned family members, and then if they meet certain eligibility criteria, they're referred to RISE. And this is being studied in a randomized control trial. And so far, we've worked with 117 cases, and we collect data prospectively across 3 points in time. So far, this is preliminary data, but 53 people have gone through these different data collection points, and we've got really promising findings. So people who are exposed to RISE are having significantly greater improvements in these outcomes: emotional support, perceived stress, social self-efficacy, general self-efficacy, and total life satisfaction. All right, I'm going to pass it back to MT.
So the importance of doing what matters most to people, of purpose and meaning, is not just woo-woo, new age stuff. It's based in serious science. So as many of us have learned the hard way here, you can change laws without realizing the intended benefits for the beneficiaries. And so one of the questions we were approaching is like, how do systems change? How do you make meaningful change? So just a few lessons that we learned. Maine, because it was based in evidence, because they liked the outcomes, expanded the program statewide, wrote it into law, funded it, and ACL has funded an expansion to several new sites recently, and we're working on that now. And the World Health Organization has selected RISE as a program to test internationally. And as for that mother's son, RISE helped him get treatment, get a job, get an apartment, and once he was more stable, she was ready to accept help too and address the safety issues in her house and begin rebuilding her own social connections. And so we think this stuff works. Thanks.
Okay, we will go in order. So next up, we have Thaddeus Pope, who is a professor at Mitchell Hamline School of Law, a fellow at the Hastings Center, and an expert on medical law and clinical ethics with particular focus on end-of-life issues. His work, including the much-read futility blog, is widely read and cited. Thaddeus?
All right, this is me, and my chapter is called Expand Right to Die Options for Older Americans. I'm going to focus now on dementia, though. So as you know, 6 million Americans have Alzheimer's, another million have some other form of dementia. So 1 in 10 people have dementia, 1 in 5 of people between 85 and 89, 1 in 3 if you're over age 90, as we heard earlier. There's a big fear of dementia. If you ask people, and there's many surveys on this, if you ask people over age 60, what are you most afraid of? Dementia is always at the top of the list, above cancer, above money problems, above everything else. It is the most dreaded diagnosis. Because of that, many Americans hasten their death to avoid living into late-stage dementia. And so what I do in this chapter is outline end-of-life options for hastening your death to avoid living into late-stage dementia. So I have 10 options that I'm going to, I don't know if you remember David Letterman, but I'm going to give you 10 options right now. And I group them in the chapter into 3 categories. Settled options, emerging options, and then future options. So the settled options, and as the word suggests, these ones have a rather solid legal foundation. But despite that, they have significant limitations in their ability to achieve the goal of the individual seeking to avoid dementia. So first option is just your regular old traditional advance directive. With that, you can refuse life-sustaining treatment. Great. The problem is that you might not ever become dependent upon that. You have the right to refuse it, but you might not need mechanical ventilation or antibiotics. So even with an advance directive refusing all of that stuff, you might still live into late-stage dementia, which you wanted to avoid. Option 2, VSED, or voluntarily stopping eating and drinking, VSED. So here, the patient is refusing all food and fluid by mouth. And if you don't take any fluids, you're going to die in 8 to 14 days. So this is again well accepted, grounded, but there's a timing problem with this, and that is that you have to VSED when you still have decision-making capacity. And the problem is that means you have to VSED far in advance of the thing that you're trying to avoid, which is late-stage dementia. So you're, as people put it, there's an earliness problem, or this is a very common phrase, you have to give up good days in order to avoid bad years. Option 3 is getting made in Switzerland. And you may have read recently about Nobel Prize winner Dan Kahneman, who just did this. So many Americans have been going to Switzerland to get medical aid in dying there to avoid living into late-stage dementia. So they go to the Dignitas Clinic or to the Pegasus Clinic or to the Athanasius Clinic. But again, the problem is all those clinics require that you have capacity when you arrive in Basel or Zurich. So again, timing problem with that option. Option 4, inert gas asphyxiation, right? So basically you put a hood over your head, fill it with nitrogen, and you die. Again, though, you still have to have decision-making capacity when you do it. So again, you have the timing, earliness problem. So those are the settled options, so what about the emerging options? And this is where a lot of my recent publications and consulting is. So option 5, VSED by advance directive, right? So instead of starting VSED right now, what you do is you write an advance directive today, what's today, Monday, saying that you not get hand feeding, spoon feeding at some time in the future when you depend upon it because you're in stage 6, stage 7 Alzheimer's. There, in the United States at least, a whole bunch of specialized VSED dementia directives have been distributed and are being completed all over the country. So big interest in this. And so sometimes people put a clinical trigger in their advanced directive, so they'll say, when I get to stage 7 Alzheimer's, that's when I want you to stop feeding me. Sometimes there's a functional trigger in your advanced directive, so you say, stop feeding me when I don't recognize myself, or stop feeding me when I don't recognize my family, or stop feeding me when I can't go to the bathroom, or whatever functional trigger you want to put in your advanced directive. Now this avoids the earliness problem because the VSED happens when you reach the condition that you find intolerable. So you don't have that earliness problem. But there's a bit of uncertainty about whether this type of directive may or should be honored, especially in the long-term care context. So option 6, and this is what's really a lot of people are grappling with now, is VSED by surrogate. So now, as you know, most people in the United States don't have an advanced directive, much less a VSED advanced directive. So now it's not the patient asking for VSED herself contemporaneously. It's not the patient asking for VSED through her advanced directive. It's a surrogate of the patient asking for VSED for the patient. Now this again avoids the earliness problem because it's happening at, when the patient reaches the conditions that she would find intolerable. But again, long-term care facilities, other types of clinicians, hospices, not sure if they're allowed to honor such a decision by a substitute decision maker. And then option 7 is medical aid in dying. Now it's available in 12 states, maybe 13. We'll see what happens in Albany later this afternoon. But the problem is with MAID is that you have to have both capacity and terminal illness. Problem with dementia is that when you still have capacity in dementia, you're not terminally ill, and by the time you're terminally ill with dementia, you no longer have capacity. So I've written a series of articles saying, well, you could start VSED, stop eating and drinking. That makes you terminally ill, and then you can switch and then you qualify for MAID. A number of patients have been doing that in the United States. So those are the emerging options, and I just want to end with the future options because this is like my research agenda here. Option 8, medical aid in dying, not having the VSED in order to bridge to MAID, but just making patients with dementia automatically eligible for MAID. And there have been bills, this one in California, for example, to do that. The reason for that is everybody prefers MAID to VSED because MAID is fast and VSED takes 8 to 14 days. But you still have the timing problem, which is even if they're going to make patients with dementia eligible for MAID, they're not going to take away the contemporaneous capacity requirement. So you still have the earliest problem. Therefore, what I think is probably the most exciting new option for the US is MAID by advanced directive, right? So this avoids the timing problem because, again, you're not going to get MAID until you reach the condition that you find intolerable. So this isn't available very many places. Spain, the Netherlands, Quebec, maybe soon the rest of Canada. But there have been bills in the US to propose MAID by advanced directive, and I think we're going to see a lot more of this. And then finally, what's going to happen because of, as a follow-on to the last option, is MAID by surrogate. Okay, so here, the patient lacks the capacity in late-stage dementia to choose MAID for herself, and she never completed an advanced directive requesting MAID, so we have no first-person authorization for this MAID, but some substitute decision maker for the patient thinks, you know what, MAID would advance the patient's goals, preferences, or values, and so they would be requesting MAID on the patient's behalf. So this was just recently authorized in Colombia by the Supreme Court there, but I think we're going to start hearing more about that. Thank you.
Thank you, Thaddeus. Our final paper on this panel is also a collaboration. First, we have Diana Urin, who is a master's student in neuroscience at the University of Ottawa, in Canada. She's working under the supervision of Professor Jennifer Chandler. I just will note that Deanna says she wants to go to law school next. So this is your moment to either talk her into it or perhaps out of it from meeting too many law professors. Jennifer will be on the panel, although Deanna will present. As I said, Jennifer is a law professor at the University of Ottawa, where she holds the Bertram Loeb Research Chair. And consistent with her research profile, she regularly contributes to Canadian government policy on contentious issues of biomedicine. So Deanna.
Yeah, all right. Hi, everyone. Thank you for having me. Like she just mentioned, my name is Deanna, and now we'll be talking about interpreting grievous and irremediable suffering in the context of medical assistance in dying or MAID. Okay, so I'll specifically be focusing on a Canadian perspective, but the discussions we have today could very likely be applied to other jurisdictions that have similar frameworks for assisted death. And so maybe the first thing I'll say about the Canadian framework is that we have a two-tier system depending on whether an individual has what we call natural death being reasonably foreseeable. If they do, we would say that they fall under track 1, and if not, they would fall under track 2. In both of these cases, though, regardless of track, an individual needs to have what we call a grievous and irremediable medical condition, alongside other eligibility criteria that would make them be qualified for MAID. Now, when we say grievous and irremediable medical condition, what we're really referring to is the presence of 3 different components that occur simultaneously within an individual. So that is that there needs to be a serious and incurable illness, disease, or disability. There also needs to be an advanced state of irreversible decline in capability. And finally, there needs to be enduring physical or psychological suffering that is intolerable to the individual and cannot be relieved under conditions that they consider acceptable. And here on the slide, I've just bolded the different components that are really talking about the irremediable part of the term grievous and irremediable. Okay, so now I want to focus on what we really discussed in the paper, which was 3 different scenarios in which it can become difficult to determine whether a condition should be considered irremediable. So the first scenario is where there is a lack of an effective or sufficiently likely cure. The second scenario is when there's refusal or interruption of an intervention. And the third scenario is where there is inaccessible treatments or supports. All right, so let's start with the first scenario that I just outlined, lack of an effective or sufficiently likely cure. So if you think back to the very first slide that I mentioned, you might recall that I said that there needs to be an incurable condition for an individual to qualify or to have access to MAID in Canada. Now, the issue is that there's no real consensus about what the definition of curability should be. So, for example, it could refer to the complete halting of a pathophysiological trajectory, or perhaps it could just be reversing certain symptoms or consequences of a condition. And as you can imagine, patients and clinicians might disagree as to what should be considered a cure. And so overall, the Canadian opinion then is that there should be a collaborative effort between the patient and the assessor when it comes to MAID determinations of irremediability. The issue, though, an issue still remains even within this collaborative framework because there are some questions that remain unexplored. So for example, who should decide what counts as being curable when the patient and the clinician disagree? Or what happens when there's uncertainty about treatment effects or disease prognosis? And does that mean that there's no reasonable treatment that exists, or simply that we don't know what it is, which would change whether we decide that something should be irremediable or not? And when it comes to thinking about older adults specifically, these issues become more prominent for several reasons. One being that there tends to be higher levels of multimorbidity within this population, which by default increases the uncertainty about treatments. There's also the concern that clinicians might be reluctant to collaborate with certain older adults that they perceive to be less competent. And finally, there's the issue of frailty, which sometimes makes it difficult for clinicians to determine whether a condition should fall under track 1 or track 2. And what ends up happening sometimes is that it's easier to say that something is track 1 when it comes to older individuals simply because they are further along within their life and closer, quote unquote, to death. And by doing this, by making people fall under track 1, what ends up happening is that they can sometimes skip over these other safeguards that would otherwise be present if they were classified under track 2. The next scenario that I outlined earlier is this idea of refusal or interruption of an intervention. And so Canadian law makes it pretty clear that individuals do have the right to refuse any intervention. And this isn't just when it comes to MAID, this is a general thing. So it's not controversial to say that individuals should not be forced to try all treatments before getting access to MAID. But at the same time, in Canada, there seems to be this opinion that individuals should also not be allowed to quite say no to absolutely every single treatment and then automatically get access to MAID. And so naturally you might see that there's this gray space between these two extremes where it becomes unclear which types of refusals should contribute to determinations of irremediability. What we do know from Canadian case law, though, is that in some cases, refusal of one form of treatment could lead to the loss of access to another intervention or liberty when there's both individual and public concerns involved. And this can become particularly relevant in the context of MAID in two different scenarios that we thought of in our paper. One being when a person refuses low-burden evidence-based treatments without compelling rationales, and another being when there are uncompleted resource-intensive treatments. Again, there are some concerns when we think of older adults. One being that older adults may simply be more susceptible to refusing more due to treatment fatigue or cognitive overload. And there also might simply be more general reception to allowing individuals to refuse treatments and get MAID due to cultural narratives that normalize things like being tired of living. And finally, the last scenario that I mentioned I was going to talk about is this axis of inaccessibility. So this was already discussed a bit earlier, and I don't think it comes as any shock to say that funding and allocation decisions can unintentionally shape state of health and worsen medical conditions while individuals wait for support. Something else that's a concern in the Canadian setting is that there are regulatory barriers that can prevent access to experimental treatments that might otherwise treat what we might now consider an irremediable condition. And so many people are concerned about this sort of landscape because we tend to value state accountability, and people are worried that allowing MAID in such a context seems like an easy way out for the state. But at the same time, it's really hard for the government to know how to react to this because courts are reluctant to impose positive obligations on governments, especially when it comes to allocation decisions in the Canadian context. And so again, there are issues for older adults when we think about this specific issue, because it may be the case that age-related socioeconomic factors decrease accessibility to care more than they would in other groups. And there might also be less efforts to actually provide certain supports that these individuals could otherwise benefit from if they fall under track 1 as opposed to track 2 more often, simply because the way that track 1 works happens in a much shorter time frame than track 2 would. And so with that, I will end. I will mention that for those that have read the paper, we discussed a few proposals throughout to address some of these issues that I described. And so if you have any thoughts on that, you can also ask right after, but I just decided to skip that out because, yeah, we were trying to show that there's many more questions than there are answers when it comes to this, and so we'd be happy to hear your thoughts on that. Thank you.
Thank you. So what we're going to do now is open this up to a discussion. And I want to begin by inviting our panelists, if they have questions for one another, questions being things that end in question marks, to pose them. Anyone want to take me up on the offer? Alison?
This is a question for both MT, David, and Joan around adult protective services, and whether you saw differences in cases that involve abuse by an external person versus kind of self-neglect, and how systems should respond to that, particularly in both of your papers, you talked a little bit about people's right to make choices and how we should think about kind of those self-neglect cases differently than someone abusing from the outside.
So I would probably make 2 points to that. I mean, first of all, there's a sense in which I can't speak to that. The health authorities actually don't keep very good statistics of what type of cases they have, which is actually documented in several reports. I'd heard this anecdotally, but I actually can now cite places where that's clearly said. Having said that, what I've heard anecdotally and what I actually think is a lot of the problems that they're having with their adult protection are actually in self-neglect cases where things are fuzzier, where they don't, the law is black and white, dementia is progressive, someone's self-neglecting, there's no easy answers. So I've actually heard people who work for the health authorities suggest that those cases should be separated out and treated differently from the abuse and neglect. But that's anecdotal rather than based on my research simply because of the problem of statistics.
Yeah, so I mean, as you know, the self-neglect's represents the highest proportion of cases that APS sees. Yes. And interestingly, so in Maine with that, that recurrence finding, that recidivism finding, our largest effect was with self-neglect cases. So they were 9 times less likely to come back into the system when they were exposed to both APS and RISE compared to when they were just exposed to APS. And then that finding kind of held true when there was like that poly-victimization of self-neglect plus, financial abuse or plus whatever, yeah.
2 additional things. First, it would be really lovely to get rid of the term self-neglect. It's sort of punitive and ugly. Second, one of our colleagues, Stuart Lewis, did some research showing that there's a high level of co-occurrence between elder abuse and self-neglect, and that in fact self-neglect does predict often elder abuse. And just anecdotally, in the cases, what we have also found is that cases that come in as self-neglect cases, if people feel comfortable working with an advocate and there's enough sort of elasticity in that relationship and time, other issues come up. And that it actually, it has allowed us, I think, to work more effectively with clients.
Thanks. Let me give the panelists another chance to ask each other questions because I see eyebrows going up. Yes, MT.
So I have a question for Alison. First, thank you, Alison, for your work as a citizen and as a whatever else I am. When we had this sort of arranged marriage or shotgun marriage between aging and disability about a decade ago, where states and counties and then the feds said, okay, you guys we're gonna conflate you, basically. One of the things that was troubling to me was that we never really unpacked or addressed the existential issues. Aging is not the same as disability. Disability is not the same as aging. They co-occur often, but how should we be thinking about that in terms of this work together? Because I think there's something really deep going on there that we have not properly unpacked.
I'll just say a few things because I could probably talk for like 5 days on this topic, having lived it on the outside and on the inside. Probably more thoughtful planning on the front end would have been helpful, but I think 13 years in now to this experiment, really recognizing the commonalities and bringing people together around those while at the same time equally recognizing those differences, I think, is really, really important. And I think at first there was too much of everything for everyone versus saying there are some things where we have common goals, it may look different. And so I hope we are at a place where now, a decade and a half in, there's more refinement and recognizing in practice, it looks different and that everything cannot be the same. I am concerned at the same time that kind of having a leadership and a place that both had a table to have those discussions and frankly, maybe forced collaboration at the state and local levels may not exist in the same way. And I think that is where my late end to the paper and in changing circumstances, I think really leaves a big question open of, are people just gonna retreat back to their silos or say there is enough of common ground and advancement that's happened from working together to make it worthwhile? And I think it's maybe an open question mark at this point.
So I'm going to take one more question from the panel before we move to the room. Jennifer?
Yes, thank you so much. So this is a question for my friend Thaddeus. So Thaddeus, my question for you is, were you endorsing all of the potential sort of avenues that you went through? I'm most interested in the idea of made by surrogate consent. And if you are endorsing that one, what sorts of protections do you think would be required around that? Of course, sort of lurking around that is the possibility of surrogate consent for other people who are incapable, who have never been capable, who are minors, who are incapable for other reasons. So what sorts of protections or limits do you see on that if you are endorsing that as an option?
I'm endorsing all 10. I don't think some are better than others. I mean, I think it's worth always, we do this a lot in MAID, is we remind people like, yeah, there's like 100 times the number or 1,000 times the number of times where surrogates are hastening the death of people in Ontario ICUs. And for the most part, we don't really check anything. If you're the surrogate and that's what you want to do, fine. I think with MAID, there are going to be a little bit more of a vetting or an investigation into why do you think that that is what the patient would have wanted. So we don't do that in the ICU context much, but I do think there have to be a little bit more push for some evidence from the surrogate that why do you think this matches the preferences, goals, or values of the patients. I'm not sure if it needs to be a judge, if it's enough that it's the attending physician, or but I agree, right? Is that I raised one, I guess I'm raising like the paradigm where it would be the adult child of the patient, but you're right, is once we go down that road, now what other types of surrogates can make MAID decisions for what other types of patients? And so you're right, we need to either explore those other situations or just draw a line and say, no, I'm only talking about this and I'm not willing to go down the rest of the road.
So I want to open it up to everyone else. Just for fun, I think we'll go in the reverse order this time. And what I'm going to do, if I can make it work, is give a 2-minute light for responses so that we can get everybody's comment and question in. Govind, do you want to start us off?
Yeah, so I think my question follows on the last question of the panel. I'm interested in what potential avenues there are for mitigating the conflict between some individuals with disabilities and disability advocacy communities and some people who see MAID as a valuable option for themselves, whether or not they think they would end up pursuing it. And in particular, so I'm interested conceptually in what avenues might do that, and then empirically, especially for Alison, in the question of, do you know anything about whether, you talked about sort of polarization, and I was curious about whether that was at the level of advocates. Do we know much about the sort of on-the-ground views of like regular people with disabilities or regular older adults who don't identify as disability or aging advocates, and are they less polarized about some of these questions?
Sure, I'm happy to start and then others can add. I think the real challenge is, going to the bucket that Diana talked about, which is people who are unable to access services. And I think that's really kind of the orientation from the disability community is inability to access services and maybe a cultural view of you are a burden and doing this for other people, not because it's what you want. I mean, there is a whole kind of movement around that. There are a lot of lawsuits that have been brought under disability rights laws. And I think really if the paradigm was people have been offered things and had full access, and this is kind of the last thing out there, and there were more protections, I think there would probably be some differing perspectives around that. I will say we dealt with some of this issue when we updated the Section 504 regulations and got a lot of comments on that. Maybe you were one of the people who commented. And I would say it's not just advocates, but it is also really kind of the experience of some people who had written in that felt like this idea was almost too much being put out there, to use really the word Diana used, of like an out from government having to provide services, and this being a first resort versus a last resort, which is why we included in the discrimination, medical treatment discriminations, not only discrimination in denying treatment, but also discrimination in giving treatment, and to really leave some flexibility in the law to think about some of those circumstances.
Sorry, is this on
Oh,
or
yes,
not?
it's on.
Okay, it's on, yeah. To give a little bit of a Canadian perspective on this, it's a really interesting problem. I think the issue has come up in the in the press over the last few years repeatedly, less in the context of accessing medical care, because to be able to demonstrate incurability of a condition, you actually have to have had quite a lot of medical care. So you almost don't get to that door of asking for aid unless you've had access to a bunch of medical treatment. The issue has been more about whether you've been able to access the kinds of sort of social supports, housing, this kind of thing that would alleviate symptoms of loneliness, of isolation, these kinds of things, socioeconomic determinants of health. This is where the real conflict has been about whether people are being neglected into seeking aid. And it's interesting right now, we have two diametrically opposed charter cases arguing discrimination using the same provision in the charter in opposite directions to say that exclusion from this option is discriminatory withholding of an option that's valuable, and then exposing on the other side is discriminatory to expose people with disabilities to this risk of death in this context of societal under-support or neglect. I think what Canada has tried to do, because it's sort of an incommensurable kind of problem to resolve here, is in track 2 to mandate that there be a relatively long period, 90 days, within which someone has to be informed of and given opportunity or to consult with a whole range of different available, and that's the important question here, available social supports, housing and income supports. But it all turns on what is available. And there we haven't really been able to resolve because it becomes a big fiscal and political question about whether what's currently available is going to be viewed as reasonable.
I'll just go in, since Jennifer mentioned these two conflicting charter cases. 3 years ago, I was part of a team, and we sued the Attorney General of California, saying that the California End-of-Life Option Act violated the ADA because it requires self-ingestion, and some patients who, like with ALS, are unable to self-ingest, therefore it's discriminatory. Right now, pending in the Ninth Circuit, is United Spinal, which is a case saying that the California End-of-Life Option Act violates the ADA because when an older disabled individual wants MAID, instead of sending them to suicide prevention services, you say, oh no, here's your prescription, right? So they say that's discriminatory. So it's like the ADA being used we were using it to expand the End-of-Life Option Act, saying federal law requires you to expand it. What the plaintiffs are, and it's already been briefed, it's just on hold because they're waiting for a standing case to come out. But now they're saying you need to strike it down completely because it completely violates the ADA all the time.
Thanks. So we're going to take 2 questions at a time. So Sharona and Leslie.
Thank you for a terrific panel. So this is for Thaddeus as well. This is actually a case that we encountered in my ethics committee, and this was an individual who was very severely disabled but not terminally ill, and he kept trying to do VSED, and after 3 days he would break down and beg for a drink because he couldn't stand the thirst. And so he was asking actually for sedation with VSED so that he wouldn't experience that suffering and he would succeed. So I was wondering if you had any opinion on that, or if that is too close to MAID, or what are the implications of that?
Great, and let's take Leslie's.
So my question was going to be a general question about the role of social circumstances. That's partially been answered with respect to the question of whether considering whether people are being driven to MAID without getting, because they don't have adequate support. But I want to make it a more general question, and I'll ask it for the definitions of elder abuse. Should what counts as abuse take into account the social circumstances of the person? So stealing from somebody is, generally considered abuse. But imagine a family caregiver herself being exploited by, in effect, having to give free care, who pilfers a little bit from the estate. That's going to be documented abuse. But should we be thinking about what counts as abuse, looking at social circumstances? And for the RISE people, I simply wanted to ask, is part of why RISE has been much more successful than the APS model that RISE actually addresses the need for a variety of social services in a way APS tends not to?
Terrific questions. Thaddeus, do you want to start us off?
Thanks, Sharona. So one option that I did not mention in the 10 is palliative sedation to unconsciousness. And, right, so basically, you're completely unconscious, you can't eat or drink, neither could you really be fed, so you're going to be dependent upon artificial nutrition and hydration, but presumably when you signed up for the palliative sedation, you also refused artificial nutrition and hydration, so you are going to dehydrate to death. But we wouldn't call that VSED anymore because feeding by mouth is not possible, right? It leads to dehydration, death from dehydration, but it's a different mechanism. The problem with that is the guidelines generally, but they conflict among different palliative organizations, is that generally you don't get palliative sedation unless you're prognosticated to already be within 72 hours of death, because the palliative, they want to be, they like to use the doctrine of double effect, and they want to be confident that you were going to die anyway, and therefore we had no causal role in your death. But they do conflict, and so some people will use palliative sedation as sort of a, I don't know what you call it, a backdoor or a secret, in Ohio where you don't have any, that it would be sort of a legitimate way to get to the same goalpost.
Other members of the panel, Joan, and then MT?
Yeah, I just make a couple comments looking at this more broadly about the question of how much circumstances fit into abuse. Certainly, the responders that I interviewed in my study, I think maybe it was their background, their training, but many of my interviewees were actually, I think, pretty good or pretty aware of looking at circumstances, and a couple of the illustrations that came up was understanding when there was alleged financial abuse, what kind of the context of the relationship was, et cetera, with the alleged abuser, what the history was, what the purpose. And then more sadly, several gave the illustration of people that, or adults that they believe could end up in care or might end up in care because they were allegedly self-neglecting. Now we're back to that self-neglect rather than abuse, but the issue was really resources, that the resources weren't available, and so they weren't self-neglecting, they just couldn't access anything. So that kind of contextual analysis came up. I don't know about the system as a whole, but certainly with some of the individual responders who are doing the investigations and providing the support.
Yeah, I guess it's true that the definition of elder abuse doesn't include a social context, but the field I think does a pretty good job of like most sort of theoretical kind of risk models contextualize the issue and understand that it does happen in different social contexts, and I think the key is that when you're responding to it, you're not taking sort of a punitive position as a default. And that part of your response is to help address some of those social inequities, for example, or areas, and to see it as a relational issue. It's not, it could be going both ways, the tensions, right? And in the case of a caregiver, they might be experiencing tremendous stress and, their own, so it's not just kind of a blaming sort of approach. And so I think you have to build that into your intervention.
On the definition question, the field has been at war for decades on that, and it depends on, the legislation, research, practitioner, they're all slightly different. For example, scams by strangers is, on the bubble in terms of whether it's considered to be elder abuse, even when an older person is targeted. So that, in terms of the definition, that's a hard hill to climb. In terms of whether I think manifestly having a more well-equipped toolbox with varying methods does help us, have better, a more capacious realm of potential responses. And especially as David was mentioning, the restorative approaches and the relational approaches. I mean, this stuff is really messy, and there are often power imbalances and long histories that, involve all sorts of messy stuff that you have to address.
Great. So let's take Jessica and Erica next.
My questions are for Thaddeus. I'm just curious, I'm prone to imagine the worst case scenario. If someone had a MAID directive in place, do or would insurance companies treat that as, kind of like a pre-existing condition? Well, you're going to opt for MAID anyway, so are we going to pay for this treatment or for this medication? Like, would they or do they use that as an excuse not to cover certain treatments? And I'm also thinking, it's not murder, so I assume you could still get life insurance payouts but I'm just wondering if there are systemic things that would dissuade or encourage people to use a MAID directive, or if that's been litigated in other places.
Erica?
Sure. Really great presentations and great articles as well. This question is more so, I think, for MT and David and Joan. With respect to mandatory reporting, I really had a question about where your thoughts were at the effectiveness of mandatory reporting, just because in seeing kind of where Canada's at with, having, I think few provinces who had mandatory reporting, or a few jurisdictions that had it, and then in here in the United States, we have every state except one, New York, that doesn't have it. So, where are we at with this, and what are your thoughts on the effectiveness of it? Because coming from my background with APS, I kind of have changed my viewpoint over time, and I'm kind of leaning more in the position of it not being very effective. But it's interesting because I just have seen, from your presentations that this could kind of play into, I think, a lot of, where we're at with providing victims with services. So.
Thank you. So I'll turn it over to our panelists in no particular order, with this small request that you keep your responses pithy.
Did you want to,
I'll be, go ahead.
I was going to say, the question about mandatory reporting is actually Nina's. She just has spearheaded a formidable paper on the subject. So go ahead, Nina.
Doesn't work? We can discuss details.
Yeah, that's right.
Is that the model you're setting for us?
I mean, I can share a couple, we can do that question first, I guess, but, I mean, so yeah, in a lot of Canada, we don't have mandatory reporting. And so I would say the big advantages of mandatory reporting is that it brings attention to the issue, it brings resources to the issue, it brings a lot of training to all sorts of professionals around the issue, and so it really elevates the issue. So that's good. It's not so good because it is sort of it kind of flies in the face of sort of a client-centered sort of self-deterrent. Like, in other words, the older adult doesn't have a choice that somebody's going to show up, call them and show up, they get involved in the system, and so it kind of, that's where it kind of falls short. And I don't think, I mean, maybe I can be a part of this discussion later. I don't know that we have evidence as to whether or not it works, but I'm not aware of it.
So I'll just very briefly elaborate. We looked at all the literature on outcomes related to mandatory reporting. And what we find is an increase in investigation rates, but not in substantiation, and no evidence of improved outcomes in terms of well-being, satisfaction, and the like. And so part of the question is, A, is it worthwhile? Is it helping? But B, is it also potentially, and there's some evidence, overwhelming systems to do the things that might be smarter as opposed to merely the investigation.
Right.
I've been working with Professor Kaplan's terrific students, and that article is now out.
And I guess the only thing I would add to all those comments is there was actually a report in BC that there was a suggestion that we should have mandatory reporting, and many of the responders or people who are in the field were very opposed because of a concern, and maybe it's very similar to what Nina was just saying about then resources going into investigating, whereas the real shortage was as far as no resources, and the problems have to do with the lack of resources, et cetera. So their thought was, this looks on paper like an easy fix, but let's address the underlying issues.
Just on the MAID, so every statute on the books now and every bill that was introduced, like for the 20 states this year, protects you from, life insurance impacts, and basically protects you from all of that. Basically, it's the same thing we did in the early 1980s with regular advance directives, which you said, just because you're refusing life-sustaining treatment, that's not suicide. It can't have an impact on, and so it's statutorily addressed to protect you from the consequences. I think I heard you say. I don't know if Diana and Jennifer want to. So Quebec has advanced requests, and I think there was just a Health Canada national consultation to expand it to the rest of the country. I don't know if you know. You're not there yet. Okay.
We do have waiver of final consent, but that's different. That's a smaller thing. But we actually, in our paper, we allude to a similar problem, which was a case we heard about of someone who went partway down the line of an expensive course of treatment. So this is not health insurance. It's the Canadian public healthcare system, which allocates resources, which might have a sort of reticence to treat people who've shown a prior interest in MAID. And so hearing about this particular case of a deep brain stimulation implantation that got stopped before the programming could be actually attempted to see if it would alleviate symptoms, speaking to the physicians involved, they're like, we don't think we're going to be so keen on trying this with people who have shown an interest in a MAID in the past. So even in a publicly funded healthcare system, we have an analogous problem, I think.
Fascinating. Okay, we're going to do a group of three. Malia, is it yours, and then Susanna, and then Julia?
Great. This question's for Alison and David and MT, but also anyone who has thoughts. I'm curious, my experience has been that with elder abuse intervention programs on the ground, almost always those are very strictly age, you qualify for them based on age, and they're not open at all to younger people with disabilities who might also be experiencing abuse. Just anecdotally, I ran a multidisciplinary team on elder abuse for many years, and the APS director in the county who funded our MDT was constantly asking to open it up to people with disabilities who were experiencing abuse, and I would always say, absolutely not. That's a totally different thing, and it's different experts. listening and reading some of your papers, I'm wondering, I would love to hear what your thoughts are on some of these programs. Is it a horrible idea or a great idea or something in the middle to open up some of these programs to people with disabilities?
Susanna?
Actually asking a question on behalf of Naomi Kahn, who is a co-author to several in the room. It's less of a question, actually. I'm going to pitch it as an idea for your revisions, because I think it's mostly that she wanted to appreciate the wonderful connections being made at the intersection of disability and aging. And to think, especially for Alison, what are suggestions for how to move forward, given the need for advocacy and state organizations or others to step in, and then sort of as an additional piece of sort of guidance or directionality, to continue to think about how issues around sex and gender play into all of these questions as we move forward with the work. So I'm not sure this requires responses in the room, but just wanted to share from Naomi Kahn.
Thank you. Julia?
Yeah, thanks. This is probably for Joan and David and MT. The first thing with mandatory reporting, my experience of mandatory reporting was looking at child protection in my jurisdiction in Australia, and the same thing came up, that it's just actually creates a lot of noise too, because there's too many reports to investigate, and people don't realise that that it gets reported, and most of them don't even get looked at. But we still had mandatory reporting in that jurisdiction, and they started another child protection inquiry, 10 years after the one that I finished on, and it's very popular in the imagination. People like this idea of telling an authority, like with someone, people used to say, well, with child protection, the same with elder abuse or neglect. In the old days, the church would just go around and give someone a sandwich and do their ironing and clean up their house. Now we report them to the government, and there's no sort of community response, so it's a way of deflecting responsibility. So how do you deal with those political exigencies and populism, that it is must be some individual's fault for this, the abuser's fault, and not systemic lack of resources? And the second one is just that categorisation of elder abuse, which was brought up just then. Is it elder abuse, is it disability abuse? But the example you've given in the paper is really, could also be categorised as domestic and family violence, certainly under the legislation in Australia. So it's also domestic abuse, and which might have been intergenerational there. I can't remember if it was a young man or a young girl a young woman abusing their mother, but to what extent or when are those sort of different categorisations useful or not? And is it, on the gendered issue, is it useful sometimes to say, well, this is multi-generational DV, the husband did it, the son's doing it, when is that useful? So two questions about the political exigencies of mandatory reporting, and then categorisation of domestic violence.
Okay, let me open that up. Alison?
Let me just briefly say on the kind of elder abuse, what was really astounding when we put out the first ever Adult Protective Services regulations, and we met with heads of APS in every single state, was despite the fact that elder abuse, Adult Protective Services covers both older adults and people with disabilities, in that room, when people were being honest, there was like one or two APS people who said they had any resources devoted to or any experience working with people with disabilities. And the one state that actually really was focused on this was a bifurcated state where they had actually two separate systems and had a very strong relationship with their state protection and advocacy organization. So what I would briefly say in answer to your question is, I think it's really important that we do think about abuse of people with disabilities living in the community. We need to do it through a lens that fits with disability, and I think protection and advocacy agencies, which are funded by ACL, hopefully will continue to be funded, are really, really important partners in doing that. I think the disability community has a very negative view of APS as not solving problems and just shoving people quickly into guardianship. So the more the paradigm changes to being a way to help access useful services and brings in the right partners at the table, I think there is a lot of value to it, but just plunking people with disabilities into like the existing elder abuse model, I think would be really a negative thing.
Other responses, Joan?
Yeah, I'd just make a couple of responses. I'm not sure I have that much to say about the political aspect of because I'm actually not aware of a lot of public pushing about mandatory reporting or that type of thing in the jurisdiction that I'm in. But on the other topic about disability and elder abuse, interestingly, the statute that I spoke about, we actually have 5 agencies that have been delegated by regulation, and 4 of them are health authorities, and they deal with elder abuse. And the 5th is an agency that deals specifically with intellectual disability. And the way that the 2 actually carry out the statute is completely different because of the needs and philosophically. So there could be some things. So I think there's a difference in thinking about resourcing and not under-resourcing one versus the other, but also being aware of some subtle differences as far as needs. So for example, if an older adult is financially abused, but they've accumulated wealth all their life, they may have a unique vulnerability that comes from developing the disability in older age once they have millions of dollars in the bank. So there can be some subtle differences about the needs of the community that are circumstantial, not specifically about the abuse. And that plays out in how the statute is being interpreted quite differently by the 2 different forms of agencies.
Any final comments from, yep.
One thing relating to Australia is that I remember hearing a presentation by a geriatrician there who said that they, in some jurisdiction, had tried to enact mandatory reporting and actually took the radical step of asking the older people in that community, which we are terrible at in the aging field, and they were manifestly against it. So I've always been struck by that. And in terms of the conflation of, is it elder abuse, is it domestic violence, is it something else, is it child abuse getting old or another iteration, I think those are incredibly important questions and ones that we have unpacked insufficiently. But the part that we have done a good amount of is criminalizing elder abuse because we've been following the lead of the domestic violence and violence against women field. And I think we're rethinking that right now, as is, as are others. But I think that's a really important kind of rethinking, both in terms of how to define the problem, but also what's an appropriate response.
Great. David?
I was just gonna say, I mean, realistically, I think the field, like, more and more evidence is coming out, as I'm sure you're aware, that, like, family violence predicts family violence predicts family violence. So if you experience child maltreatment, you're significantly more likely to experience domestic violence in middle adulthood, and you're also more likely to experience elder mistreatment in older adulthood. And so I think the field is really moving towards sort of more of a life course lens in understanding family violence. And we don't understand the mechanisms. What are the actual mechanisms that connect these things? But I think that's where things are going to be heading in the next several decades. And some of these things, like, should we call it, domestic violence, almost becomes, the labels aren't as important as kind of the mechanisms that link them, I think.
Great. So let's take our remaining questions. Dick, Minotho, Francis, I don't know if you want to jump in as well. Okay.
2 quick questions for Thaddeus. Number 1, have you found any predictive factor on whether a state will adopt MAID? And 2, related to that, have you developed any theory as to why only 12 states have adopted that in the 30 years since Oregon passed their Death with Dignity Act? I just, as a reference, note that the advanced directive movement swept the country. All states now have an advanced directive. The surrogate decision-making process is now accepted in 46 states. This one does not seem to have the same resonance.
Okay, before we answer that, final question, yes.
Thank you. So my question is, I've realized that we've been focusing on the legislative aspects of MAID, So I just, out of curiosity, wanted to ask Thaddeus, I can't really see the names, and the last two speakers as well, whether they see how they see this intersecting with the position of physicians who are asked to carry out such directives, either the advanced directive or through surrogacy. And because if you look at it this way, for example, they have to balance the respect for prior autonomy against their duty to do no harm or navigating their conscientious objections. Do you think that the law sufficiently addresses these ethical tensions, or is there a gap? Thank you.
Terrific. Jump right in.
I'm not a political person. I guess I'm just a law professor. But obviously, it's all blue states, right? I mean, so that's one predictive factor. It may be, like I said, it may be 13, right? I mean, as I understand New York politics, they don't send it to a vote on the floor unless they know they have the votes already. And the governor already said she'd sign. So, yeah, I don't know, right, why it's only 12. It's hard, yeah, it's absolutely. Now, many states have passed both chambers, like Nevada, twice, and it gets vetoed, right? So they actually have the votes in Nevada, but one, just the governor could veto. So the main opponents, of course, have been the Catholic Church and disability rights organizations. And I guess they have, yeah, so on the other question, yeah, I mean, so the idea is if you don't want to have anything to do with it, this is the rule, right? No patient who didn't want to have anything to do with MAID ever had to participate with MAID. No clinician who didn't want anything to do with MAID ever had to have anything to do with MAID, and no entity, whether hospice, hospital, anybody else, who doesn't want to have anything to do with MAID, you don't have to have anything to do with MAID. So the conscience-based opt-out is broad and robust. And generally, I thought that would have been enough, which is like, if you object to it, you don't have to participate with it at all. But that's not good enough, right? It's like abortion. It's not enough that I don't want to have an abortion. I don't want anybody else to have one either, right? And so that's sort of the way this works here, which is I don't want to have MAID, and I'm not going to give MAID to my patients, but I don't want any other doctor in the state to give MAID to his patients either.
Well, we are at time with this panel. I want to thank our panelists and everyone else here for the rich discussion.